Well, I think we have some participants here. So thank you everyone for joining us for this webinar titled Know the Masters of Law. I, along with my co-examiner, Nivvy Venkataraman, Senior International Case Counsel at AIAC, would like to welcome you all to this webinar. I hope everyone is doing well during these tough times and keeping safe. Tough times, but I'm sure they're going to pass soon. One of the positives that we have of the current situation is that we have been able to get hold of Mr. Toby Landau, which otherwise would have been a very difficult situation in normal circumstances. Mr. Toby Landau is a known name and a known face in the field of international commercial arbitration and investment treaty arbitration. Mr. Landau is qualified to practice in many jurisdictions, latest being Singapore, where he has been called to the bar of Singapore on permanent basis. Our endeavor today would be to learn a bit about his non-legal side and learn from his experience and knowledge. At the end of the session, we'll have a question and answer session as well for 15 minutes, so keep making your notes. Now, without further delay, we will start with this interview. Mr. Landau, thank you so much for joining us today and giving this opportunity to interview you.
Thank you very much. It's a great pleasure.
Now, starting with the interview, we would first like to know, with one of the basic questions, that what inspired you to pursue a career in law, and more specifically specializing in international commercial arbitration or treaty, investment treaty arbitrations?
I'd like to just start by noting my concern that you're calling each other co-examiners. So this may be more of an interrogation than I had actually signed up for, but anyway, here we go. So what inspired me? I have to say that I am the first lawyer, was the first lawyer in my family. So I come from a long line of doctors. They were all medical specialists. And at a young age, it became very clear that none of these sciences needed any assistance from me. I was perfectly prepared to lend time to chemistry and physics and biology, but none of them thought that that was needed, and they were all fine without any contribution from me. Having failed all the sciences, I then moved to the arts and moved into, started to get interested actually in law at an early age, but not domestic law. I had a very keen interest in international relations, international policy, and it was international law that captured my imagination from early on. And actually, arbitration as a field is this curious cocktail of an international law field that's accessible for practitioners. You can practice in it. Many other areas are quite narrow and rarefied. And it's an interesting combination of contract, international law, conflicts of laws, all of which I was very, very interested in, plus travel. And so that all kind of came into this mix, this cocktail mix that ended up in arbitration. Arbitration is something that I then studied at university. I studied in the States, specializing in it. I spent some time in Thailand as one of my first jobs as a government legal advisor when they were starting up an arbitration center. And then when I came back to practice, it was a sort of an obvious area for me to focus on. And that was, but the question you asked actually was commercial arbitration and investor-state arbitration. So my route to arbitration was as I've described, but there was no investor-state arbitration at the time. We forget that investor-state arbitration is actually still very, very recent. When I studied arbitration in the States, ICSID was mentioned for about 5 minutes because there were no cases, and it was felt just to be of academic interest only. So people of my generation started in commercial arbitration, and then around about the mid-90s, 1995, investor-state arbitration really began properly. People started waking up to it. And then all the cohort of grubby commercial arbitration lawyers reinvented themselves as purified public international lawyers and started specializing in treaty arbitration. So that came much later for everyone. Now, things are different because you can actually specialize in investor-state arbitration from the start.
Thank you. That's very interesting to know. So does it mean that if you were not a lawyer, you were a doctor or someone else?
Well, if I hadn't been a lawyer, I would not have been a doctor because nobody would have allowed me to become a doctor. especially all the authorities. If I hadn't been a lawyer, I think I would have been a diplomat. That was the other competing interest, but partly for the same reasons, because it was international relations, international policy, and travel. So I think that in another life, mind you, I should just tell you, in my next life, I'm coming back, if I can arrange it, I'm coming back as Indian senior counsel. Yeah.
Why is that?
Because I've discovered that Indian senior counsel are a blessed group, a very, very small group of individuals who command respect and in a way that is incomparable in any other walk of life. And a lot of them, not naming any names, manage to do so even without reading any papers.
Brilliant. Yeah, that may not be the case going forward with the number of senior counsels increasing in India.
Toby, with a success story like yours, there would have undoubtedly been some level of sweat, struggles, and even sleepless nights to achieve the heights that you've achieved in your career. So for the benefit of our audience, could you shed a bit of light on your journey to becoming a successful international arbitrator?
Gosh, well, you say that there was a lot of sweat, struggles, and sleepless nights. I'd like to reassure you and everyone that there is still sweat, and there is still struggle, and there are still sleepless nights. I think it's quite a punishing profession. If one is engaged in it as one has to be, it's all-encompassing, and it takes over one's life. My story is one of luck and one of being in the right place at the right time. People say that I think it can be disheartening when you hear that, because you think, well, will I be lucky, or will I be in the right place or the right time? But there are many opportunities and many things that come along which you'd never expect. And I think that's true for many people, actually. In my case, when I started in practice, the timing was just at a critical moment in England, where the government was trying to draft and promulgate a new Arbitration Act, which became an act that became the 1996 Act. So I started in practice started as an apprentice, a pupil in 1993, and then became a tenant and permanent member of my chambers in 1994. And that was just at the point where the story of drafting the act had become one of great infighting and tension and hostility. There was a draft in play that nobody liked. The government had gone out for a public consultation on it. Everybody was united for the first time because everybody hated it. And there was a question as to what to do. So the government was looking around for somebody young and available and cheap to be brought into government for a period to work on this project. And I was very lucky in actually being selected for that. So I actually spent the first period of my practice for about 3 or 4 months in a windowless room in the basement of the Department of Trade and Industry in London, where I sat sifting through hundreds of public consultation responses and working on how to collate them all. That was 3 or 4 months sat next to a sign on the wall which said, "Danger, asbestos."
Yeah.
So it's a very salubrious beginning. And then being in the right place at the right time, when the work was done, the committee that was going to draft the act was headed up then by Lord Savile, and he decided that he would take a month out of judging, and I would take a month out of practice, which, by the way, wasn't a problem because I had no practice. And we would sit together in my room in chambers and draft the Arbitration Act. And that's literally what we did for a month, the two of us. My room was the smallest room in chambers at the time, and he didn't have any space on the desk. So he balanced all the papers on his knees, and we drafted. And that was interspersed with trips to his favorite local Indian restaurant, which he insisted on going, which served fluorescent chicken tikka masala. And much of the act was drafted there, in fact. And I say all that because that was the real beginning. For me, that was a moment to actually get into the field, having contributed to a piece of legislation, which then led on to some recognition in the field. And that led on to then starting to get instructions and being brought in as a junior in cases. So the story really is one of trying to find a foothold in the field. It's a competitive field, and it's full of people wanting to wanting to progress. And one has to find a way of distinguishing yourself from everybody else. There has to be a reason why people look at you and think, well, maybe you can add value, or you can contribute something. So that was the luck that I had. And I think many people have other similar stories where perhaps they get instructed on a particular case at a particular time, and that's their launch.
Thank you. Thank you so much. That's very interesting, because you rightly mentioned it's about grabbing the right opportunity. Moving on, you're a gifted orator, known for your advocacy and cross-examination. Have you ever, personally been cross-examined yourself, and how was that experience?
Yes, I have. In fact, I've been cross-examined a couple of times as an expert, supposedly, on law. The last time I was cross-examined was 2 days ago, where I sat in this chair and I was cross-examined before a court in Bangkok in Thailand. So an interesting experience in this new remote world. I provided an expert report on a number of areas of English law, and I was cross-examined by Thai counsel before a Thai judge. The other time, notably, that I have been cross-examined was before the High Court in Lahore in Pakistan, where I was appearing as an expert in a case which was the first time that Pakistan applied the New York Convention. And I was examined on questions of the operation of the New York Convention and public policy and international law related to that. You say, how does it feel? I think it is difficult to be cross-examined if you spend a lot of your professional time cross-examining, because it's difficult to relax, actually. I would give lots of advice to people as to how to be cross-examined, but when you know how it works, then it's difficult to put that out of your mind. Instead of just answering questions as they are, it's difficult to resist the temptation of deciphering what the strategy is and what the next question will be and what the next or the fifth question will be. And so my approach often is to say, well, I know where you're going with that question, which of course is irritating because you're just not answering the question straight, because cross-examination is nothing about question and answer. It's about strategy. It's not a genuine question, and it's not a genuine, I mean, of course the answer must be a genuine answer, but it's so strategic. It's quite difficult, I think, to be on the receiving end, but useful. But my experience in Lahore was a very different experience, and I don't know if I should take time now to explain it, but it is something that I do describe very often because it was a formative experience being cross-examined in the Lahore High Court.
Of course, I mean.
So, well, it was quite unique. People are not cross-examined so often in the Lahore High Court because trials are normally done at the lower court level. And it's not often that you get an Englishman cross-examined in the High Court in Lahore in Pakistan. And so I was called to give my testimony, and I stood up in front of the court, and word got round amongst all the other courts that there was an Englishman being cross-examined in another court. So everybody left their cases to come and watch. It was like a zoo atmosphere. It was like a massive bank of people all standing there watching to see what this would look like. The difficulty, however, was that the opposing counsel couldn't find anybody who knew anything about the New York Convention to ask me questions on my report. In fact, they couldn't find anybody on any international law aspect. So they brought out a very skilled, I think, criminal lawyer who approached me in his examination as a sort of murder suspect. And he started to ask a lot of questions which were completely irrelevant, but in their way, they were brilliant because I couldn't answer them. So his questions were like, for example, Mr. Landau, where were you on the day that you say you qualified as a barrister? Which is a masterful question because I have no idea. These questions went on and on. Each time the question was asked, the judge would write down the question because that's the way it works there, which would take time. And then he would write down my answer. So the exercise was getting more and more painful for the judge. My answers were getting more and more facetious. And in the end, the judge abandoned the whole exercise. He was so irritated, very, very good judge. He was so irritated. And he said, this is not helping me. And then he paused and he had this moment of inspiration and he said, Mr. Landau, would you mind asking yourself some questions? So the truth is I cross-examined myself. And this was to much amazement to the many, many people who were watching, thinking this man is mad. But I framed my questions carefully. They were written down, and then I answered them. And I don't want to boast, but it was one of my better cross-examinations. I got a number of concessions on the way. I forced myself to answer yes or no, even when I didn't want to. And that was the way we progressed. So the answer is yes, I have been cross-examined.
Well, that was a really interesting experience that you shared with us. And, you did touch on the fact that you ended up doing your own cross-examination. So for the benefit of younger practitioners and also arbitrators, what, in your opinion, would be the top 5 do's and don'ts when conducting a cross-examination in international arbitration?
Cross-examination is it's a very complex exercise. I personally think it's one of the hardest elements of advocacy, one of the hardest elements of one's role as counsel, because it's not a known subject, it's not a known quantity. It depends on your witness and the answers that you get. And it's very easy to get it wrong. It's very easy to make it an unproductive exercise. So if you're asking for 5 points, I think I'd say, firstly, you need to ask yourself the question before you start, why are you doing it at all? Why are you cross-examining this particular witness? It's not a given, unlike court, that you need to cross-examine everybody. In many court systems, there is an assumption that if you don't challenge evidence, you are accepting it. So there's a requirement to traverse the evidence, contradict the evidence. And so you need to be calling people. In most systems of international arbitration, you don't have that rule. Indeed, you can't have that rule because you have limited time. So there would never be time enough to cross-examine everybody. So you must ask yourself the question, do you need to cross-examine? And if you need to, why? What are you going to try and achieve? What is your plan? Just cross-examining for cross-examination's sake is a grave mistake, and it can backfire, because what you're actually doing in an arbitration by cross-examining is you're giving the witness a potential platform. If you don't call the witness for cross-examination, their testimony normally will remain in writing as a witness statement. So the tribunal may or may not read it. Hopefully they will read it, but it won't have the same life as seeing somebody in person. And in person, somebody can breathe probity and impact into their written testimony. So you run a risk. If you want to cross-examine somebody, you're calling them, and they will then be able to fix the tribunal with their eyes and tell their story. So you've got to be confident that that won't backfire. So I think that's the first key point, is to really have a plan, a brief military-style strategy as to what you need from the witness, and then you craft your examination accordingly. The second one is what everybody will tell you, and you can't repeat it enough. In fact, this should be points 2, 3, 4, and 5, and that is prepare. The single most important key to a good cross-examination is preparation. You've got to know the record completely. You've got to know every point, and you've got to have it at your fingertips. Cross-examination is not so much about the first question you ask, it's the follow-up. It's what do you do when you get the answer? So you say to your witness, isn't it right that? And the witness says no. What do you do then? Do you then say, right, fine, next question? Obviously not, you have to have follow-up. So what is your follow-up? Your follow-up has got to be to know the record so well that you're able to then say, well, now please take volume 3 and look at document 16. Isn't that irreconcilable with the testimony you've just given? That takes me to the third point. Every question, every single question in cross-examination has to be carefully crafted. And it's got to be precise, and it's got to maintain control. The best cross-examination is one that locks a witness down, doesn't give the witness room to expound too much or for maneuver. It's not so much about trapping. as just about being precise and guiding the witness through exactly the territory you want to cover, not what the witness or the other side wants to cover. The golden rule is always you don't ask a question unless you know the answer. But there's much more to it than that. It's about actually controlling closed questions which don't allow for somebody to say, well, I'm glad you asked me that. I'd like to now give you a 5-minute discourse on a range of related points. Of course, that's unavoidable if in fact there are related points, and you'll have to be ready to deal with them. But the framed, closed nature of questions is vital. The fourth one, I'd say, is something which I see a lot in cross-examination. I see it as counsel, and I see it as arbitrator, and many arbitrators will tell you when they're being candid that this is very irritating. Many counsel use cross-examination as an exercise simply to, this is one, I'm just demonstrating something, by the way, live, which is don't have your mobile phone on. So this is all planned, I should tell you. My phone's just gone off to make the point that you must keep your phone off. I hope I've demonstrated that in a clear enough way. And I'm now switching it off also live, so you can see the importance of it. The next point I was going to say is don't do what many counsel do, which is they use cross-examination as a method of reading documents. It's very tempting to do this. You often as counsel feel that tribunals may not have read all the documents. And so you want to show them a document, and the best way to do it is through a witness. So you say to the witness, Mr. Smith, please take volume 7, look at tab 3. You see that document? And the witness will say, yes, I see that document. And you say, well, can you please read the document? Read it to yourself, and everybody in the room will read the document. And now that's your key document, and you're happy because the tribunal's read it. And that's the end of the task. And then you've got to think of a question, because it's cross-examination. So the tribunal, the counsel will often ask the most ridiculous question, which is, does the document say that? And the answer will be, yes, that's what the document says. It's so irritating. This is the task that often counsel feel is a productive one, and it's not. And what happens is tribunals get irritated. So if you are going to use this to get key documents in front of the nose of your tribunal, think of some seriously good questions about them, but not questions that might damage the document. If the document is so good, you may not need to cross-examine on it. That goes back to my first point. And the fact of tribunals possibly being irritated takes me to my last 5th point. That is, don't irritate the tribunal. Cross-examination can be irritating to watch, especially for tribunals who are not used to it. And that's why arbitration is different from court, because many tribunals are not used to it if they come from different backgrounds. If you don't take that into account, if you're not sympathetic to that, then you may just progress in, for example, an aggressive way at length without realizing that you're irritating the tribunal, or the tribunal starts to build sympathy for the witness. They feel this is a common law, brutal exercise, which in more refined civil law systems they don't do. So be sensitive to your tribunal, because the worst thing you can do if you want to persuade a mind is to irritate it. Those are my 5 points.
Thank you. Thank you, Mr. Landau. But what advice would you give to a young practitioner who also sits as an arbitrator when they're faced with aggressive cross-examiners in the course of arbitration proceedings? Maybe like someone from the Court of Lahore you encountered.
So you mean what should somebody do if they're sitting as arbitrator?
Yes.
Yeah. I think this is interesting because this happens a lot. You'll be sitting as arbitrator and there will be things that happen in the room which are counterproductive. It can be overly aggressive cross-examination. It can be overly aggressive counsel who might be hitting the table and shouting objection the whole time or interrupting. And you put the question as, what should a young practitioner do? I think a young practitioner should do nothing different to an older practitioner. And an older practitioner, a good practitioner, would actually skillfully reduce the temperature in the room. That's part of the role of a good arbitrator, in my view. I think of people who have affected me, influenced me in my professional life. Some of my mentors, and the one that stands out more than anybody else is Johnny Vida, sadly passed away recently. He had the most singular ability to go into an arbitration hearing, however fraught, however aggressive people were, and to bring an atmosphere of calm and to build a sort of build a relationship, an interpersonal rapport with everybody amongst each other in order to keep the temperature down and then to keep the atmosphere most conducive to a productive exercise. And he did that by charming individuals, by actually creating this rapport with each individual and by asking them very gently to do things without undermining anybody. I think if senior practitioners can do that, then junior practitioners can do that as well. If you are appointed as an arbitrator, you have an authority, you have a position, and you have to step up to that. And culturally, that can be awkward, especially in some Eastern cultures where there's much more respect between juniors and seniors. One has to still see for the good of the process that it's not just about deciding issues, it's about facilitating the process itself as it goes along, maximizing everybody's feeling about it, their acceptance of it. And that is an exercise in psychology as well as it is an exercise in law. So I think if you go into cases with that in mind, that there's a sort of an interpersonal skills set as well as the legal set, and you work on that and you work on everybody, then that's the optimum. And what should happen, doesn't always, but what should happen is everybody should leave the hearing feeling satisfied. That's really the key.
And Toby, when it comes to cross-examination, generally there are two types of witnesses that are cross-examined. You have the factual witnesses or you have the expert witnesses. And sometimes when it comes to expert witnesses, what happens in some proceedings is that you hot tub the expert. So you basically concurrently cross-examine all the experts. So in your experience, does the technique used for cross-examining factual witnesses differ when you're cross-examining expert witnesses?
Yes, it definitely does. Cross-examining an expert is a different prospect to a fact witness because you're dealing with somebody who is technical. So in your own preparation, you actually have to become as technical as the expert that you are cross-examining. And you've got to treat them with respect. Of course, not always. It may be that some experts are not expert and they're not worthy of any respect. But in terms of the optics in front of the tribunal, it's much more of a professional discussion than it would be with a fact witness who may be vulnerable, may be less used to the situation, may engender more sympathy from the tribunal. But having said that, you have to be as firm with an expert, whoever they are, as you might be with a fact witness. I have cross-examined experts who are very, very senior, extremely senior. I have co-cross-examined one expert who was a Nobel Prize winner. The idea of someone like me asking questions, who's not expert, asking questions of an expert of that stature, it's incredibly daunting. But at the same time, that is your role. And experts, if they are party appointed, are vulnerable to being polarized or influenced or overstating. So however technical they are, there is still unpacking to be done. So all of that means that the process is different. Your end result is not so different because I'm sorry, my phone is fighting back actually, because having tried to switch it off, it has somehow switched itself on again. And this is more of a lesson, I think, than anybody would have intended I would give about mobile phones. It's now off. I think the process is different. The other thing very, very important to think about in terms of how you approach cross-examination of an expert that people don't generally think about, and this only occurred to me when I started sitting as an arbitrator. The exercise we have now of party-appointed experts being used to give testimony one after the other, being cross-examined by counsel, actually renders, in many cases, the tribunal's task much, much more difficult than it might otherwise be. It's more difficult than having one tribunal-appointed expert who's being questioned, because you actually have to marry two sets, sometimes more than that, two sets of testimony, which is being provided to you by way of cross-examination, a number of closed questions. That can be very, very complicating. If the area is technical, the tribunal may find it very, very difficult to actually follow, to really understand what's going on, because all they're getting are answers to closed questions from one side, and then answers to closed questions from the other side. They're not getting a lecture or a grounding or a priming. Now that's where hot tubbing is much better, where you put the experts together and the experts can actually question each other, or one question could be put to one expert and then directly to the other expert. And then you can see whether they agree or disagree and where they agree or disagree. That makes it much easier for the tribunal. But the exercise of cross-examination then is much, much more limited. But where this leads me is to the fact that when you're cross-examining an expert, you want to bear in mind not only questioning their credibility, not only putting your position that you may want to put and undermining their testimony, but also making sure that the tribunal in the process understands. And that may mean taking the expert through areas that are basic, that are still simple. And you can do that in cross-examination. They can be fairly safe territory if it's not controversial, but it does the very important task of educating the tribunal. Tribunals, because they want to retain their own credibility, will rarely admit that they are not understanding. Sometimes they do, but they may not admit that they're not understanding the real basics. They may just want to ask clever questions. So don't assume that they do understand, and that's where cross-examination can be useful in actually doing some of the groundwork as well as more technical, detailed work.
Coming to the cross-examination in investment arbitrations, are there any special considerations for how to handle a cross-examination in an investment arbitration as compared to a commercial arbitration?
I think we've arrived at a curious situation where we have, for whatever reason, imposed on investor-state arbitration the commercial arbitration model. There's no reason for doing that, but that's what we've done. It comes out of the references in treaties to the UNCITRAL rules. It comes out of the structuring of the ICSID rules, and it comes out of the people who are running these cases, who, as I was mentioning earlier on, are really all well trained or grew up in commercial arbitration. So the model we use is the same. It's the same model of cross-examination, same model of submissions, oral submissions, written submissions. So I think in that sense, it is the same exercise when you have to cross-examine a witness. What is different, perhaps, is that in investor-state arbitration, firstly, the issues can be more sensitive. They can be more policy-based because they tend to deal with questions of sovereign discretion, questions as to how governments decided to behave in the way that they did. And that means often cross-examining high-level government officials, ministers, ex-prime ministers, leading people in the administration. So the cross-examination sometimes is really a very high-level people and might have to be dealt with in a slightly more diplomatic way as a result. And the other factor is that the tribunal in an investor-state setting might, not always, but might have amongst its members pure public international lawyers rather than commercial lawyers. For example, ex-ICJ judges, people who are used to more of a diplomatic approach to litigation. And so going back to my previous recommendation that you don't irritate the tribunal, that means that a cross-examination in that setting sometimes has to be more delicate, a little bit more refined, a little bit more sensitive to the nature of the issues and the nature of the people involved. Other than that, I think that there is little difference actually.
Toby, you're someone who's worked on over 300 international arbitrations, and obviously you've described the fact that arbitral tribunals can be diverse. Obviously, parties and counsels and witnesses can also be culturally diverse. So in your experience, what sort of cross-cultural issues are commonly encountered in arbitration practice, and how can counsel and arbitrators effectively deal with such issues?
That is a massive question. It's a fascinating question. It's a question that warrants an extended period of lockdown and a continuous webinar. But in a limited time available, I suppose I just point to some. I mean, there are one of the interesting features of international arbitration is the cultural mix. The scope for cultural conflict or cultural misunderstanding is absolutely massive. And I think it happens in very subtle ways. Sometimes it's obvious and sometimes it's not so obvious and you have to pick up on it. I think the cultural tension plays on a number of different dynamics. Dynamics between counsel, that's counsel and opposing counsel who come from different legal traditions. The dynamic between counsel and arbitrators, who again may come from different traditions, different backgrounds, different expectations. It also happens between counsel and witnesses. That of course can happen in litigation also, but it's very, I think it's perhaps more common in the field of international arbitration, where there's a sort of cultural difficulty between counsel and witness. Now, a lot of this cultural difference comes from expectations. What are your expectations of the process? What do you think your opponent should, how should your opponent behave? How should you behave? And mostly, that is a feature of your own upbringing, your own legal tradition. So the cultural issue comes from people coming to the arbitration, but not switching out of their original mindset or their home jurisdiction. And that will be people who come and they feel they are going to argue a case in the following way because that's how you argue cases. Now, I'll give you an example. I have sat, I can't name names, it's very tempting, but I've sat on an investor state case as arbitrator where I was sitting with two other very, very well-known, very highly respected international lawyers. One of them was ex-ICJ. I'm pausing because I'm trying not to make the case too easy to find. In front of us, there was a team of the highest level respected English barristers. The English barristers began the case, opening the case in a way that to me was totally understandable and to be expected. They opened the case as they would an English case, an English commercial case. And that meant a very extended opening argument where they would ask the tribunal frequently to pick up volumes, turn to various pages and look at documents. And even cases, read cases to the tribunal. Please take this volume of authorities, look at this case. Now look at this portion where the judge said this. Now to me, that's absolutely to be expected. When we went for the tribunal rose for a break, 15-minute break, the other two members of the tribunal were aghast at what was going on. They hadn't shown it, but they said to me, what on earth are these people doing? Why are they asking us to read these documents and read these cases? Are they assuming that we don't know the law, that we don't know the cases, or we haven't read the papers? And it was fascinating because it's just a mismatch between what you expect should happen and what actually happens. And that cultural difficulty is frequent and often it's unspoken, but it can be very powerful. So the lesson from that is you must jettison your own assumptions and the way that you think you should be doing things. You've got to actually think of the field as truly international and be ready to do things differently and read the situation as to what might be expected and what not. At the risk for just nattering on for too long, I'll give you one example though, where this cultural conflict has happened, where I've experienced it, between counsel and witness. As I said that it goes counsel and counsel tribunal, but counsel witness, there can be major cultural issues. Some years ago, I argued a case in Hong Kong, and it was a case where, in the course of which I had to cross-examine a retired Supreme Court judge from the PRC, a very, very senior, highly respected judge, Supreme Court judge from China. At the time, unlike now, I looked extremely young because I was extremely young. So that was an issue, firstly, because there was a young lawyer asking questions of a very, very senior Chinese judge. To him, this was a humiliation. How could I ask him in cross-examination closed, what sounded like aggressive questions? This was made worse because it was through a translator. And I think in the translation, the questions might have even sounded even more aggressive than the way I was framing them. This is somebody who in his life probably never was forced to answer a question in this way. It was even more humiliating because he was doing it in an arbitration, surrounded by people looking at him, with 3 arbitrators judging him, and it was all being recorded. Now, that's a cultural issue. For most other people, other Supreme Court judges in other systems, they would understand the process. He didn't understand it. So every time I asked the question, his cultural reaction to it, his way of responding to it, was not to answer the question, but to laugh. So I asked the question, it gets translated, and he laughed. This was not a productive cross-examination, especially because my questions were not supposed to be funny. So what happened in the end was, luckily, the tribunal was very alert to what was going on and saw that this was a cultural issue, and therefore actually stopped the cross-examination and restructured the process so that he would not be humiliated, so that he could preserve his own dignity, which is very, very important, and actually provide his testimony, which I perfectly understood, although I was very disappointed. But so what happened in the end was the tribunal actually asked him simply to make a series of statements on where he disagreed with the other expert and to expound on issues without being put on the spot in this way. So I think that's also the beauty of arbitration. It's a mix of cultures, but also it's flexible and it has in it the solutions which you just have to find.
Thank you. Moving from the cross-examination to oral advocacy in international arbitration, which I think is one of the charming factors for young practitioners because they want to do advocacy before a tribunal in international arbitrations. What would be your top 5 tips for a young practitioner who seeks to improve his or her oral advocacy skills?
Oral advocacy is a skill which one is forever learning. So it's not something which you just learn and then you can do it. Everybody is always learning. I am still learning. Everybody who has an interest in it will always feel that they're learning. And the way that one learns, I think, is to try things and to see how other people do things. So the advice to a young practitioner is to place yourself in a position where you can do that. I think firstly, you must have the right mindset as a young practitioner. And the mindset, I think, is to be open-minded about advocacy. And by that, I mean, do not approach advocacy as simply any other technical skill where there are ways to do things, set ways of doing things, because there aren't. One of the problems with any system that teaches advocacy is that it often teaches it in a formulaic way. So if you make an application to the court, you must do the following 10 things, and you do it this way. And then you try it out and you're marked on that basis because there has to be some way of regularizing marking. And that's the wrong mindset because advocacy is malleable. It changes from scene to scene. There are many different ways of doing things, many different situations that call for different types of advocacy. So the first key point, I think, is to be open-minded and think creatively about it. And that leads to the next point, which is to watch as many people as possible, to see who's good, and even more importantly, who's bad. You can learn so much from bad advocacy, from watching people and realizing they're not effective. They're difficult to follow. They're not clear. They're confused. So watching people and thinking through how they're doing something is very, very valuable, whether it's in arbitration or whether it's in court, whether it's good or whether it's bad. I think the next thing I'd say is the single most powerful way to learn advocacy, most effective, is actually to be on the other side of it. Now, sitting as arbitrator or judge is not an option when you're starting out, but being a legal secretary to an arbitral tribunal is an option, or assisting a tribunal. If you ever get the chance to do that, and there are many opportunities around the world to do that now for young practitioners, many institutions that you can write to and offer yourself as a legal secretary, an assistant to a tribunal. Many practitioners you can write to. I get written to out of the blue all the time by people who say, I'm available to be hired to help as a legal secretary. And so it's very, very useful. There's an incredible perspective you will get the minute that you step on the other side of the table. The minute you're not sitting with counsel and you're learning with them and you start listening to them. This is something I often repeat, but I have to repeat it again because it's so true. My revelation when I started to sit as arbitrator, I often say it, when I started to sit as arbitrator, my revelation was how irritating counsel are. And that's not a revelation I had without having the benefit of sitting on the other side of the table and listening to somebody and actually wanting their help and thinking, you're not helping me at all. You're just making this more difficult. You're making it confusing, or you're being irritating. You're doing things that are distracting. So that perspective is so important. And I would recommend that to all young practitioners to try and get an opportunity of sitting with a tribunal. The other important part of that is you then get the benefit of retiring with the tribunal and hearing their deliberations and hearing what actually happened, what's going to affect them or not. So again, I don't want to be too long. I'll give you one quick little example I have in my memory of this. When I was still at university, I applied to be what's called in England a marshal. And I think many countries have the same system which you can apply for. And that's to sit with a judge in a lower court. And you sit with the judge even just for a few days. They're called marshals in England, but it's like an intern with judge. So I sat with a very well-known, very talented, very respected county court judge in England. And we heard argument from counsel. I hadn't been to many hearings before. Counsel stood up and he made a impassioned argument. He was very, very confusing, actually, in the way he was making his submission. So I found it very difficult to follow. And he had a big belly and a waistcoat, and his waistcoat was too tight. When we got up from the hearing and went back into the judge's room, I said to the judge, what did you think? And I kind of offered my views, thinking we'd just talk about some of the issues that had been debated. The judge paused and he said to me, do you know what I find very difficult? I find it difficult when people who are overweight wear waistcoats that are too tight. Because what happens is the waistcoat rides up and you can see the shirt below. Now, I give this example because it just shows that the counsel had no sense of what he looked like when he was arguing. And if that was something which the judge noticed and said first of all, well, what can you say about the quality of the legal argument, the oral advocacy? It's all a package. And it takes listening to somebody and seeing that happen to realize that's not an effective package. I'm not saying that if you're overweight, you can't make submissions, but you have to make your whole presentation persuasive, depending on who your judge is. Of course, that's a silly example. There'll be many examples which are more serious, but something you do is distracting or irritating or doesn't help. So that is the third of, actually I've spoken for a long time, you probably think I've made 70 points, but that was the third point, which is try and listen to advocacy. Very quickly, fourthly, try and do advocacy whenever you can. Any opportunity, take it. The more you do, the better you get. And that's true for everybody in this field of any level of seniority. Do cases pro bono just to get the advocacy experience. Take any opportunity of that sort. Do cases beyond your comfort zone. Small cases, tiny cases. And every time you do it, you will build up confidence. You'll try things out. And then you'll start to learn, or you'll carry on learning. And I think lastly, that includes things beyond cases, debates, moots, any public speaking opportunity, even making presentations in front of friends and family. Public speaking is public speaking. The more you do it, the more you will find your own way of optimizing it.
Thank you so much, Toby. That was incredibly insightful in terms of how young practitioners can improve their oral advocacy skills. And you're right, it is a lifelong learning experience. Now, just moving on to the elephant in the room, the COVID-19 pandemic. Now, obviously, COVID-19 has placed us a high level of reliance on technology to facilitate dispute resolution. So in your view, do you think virtual hearings will become the new norm in arbitration practice? And what impact do you think a virtual proceeding might have on cross-examination and oral advocacy in general?
It is already becoming the new normal. in the sense that people are now resorting to virtual hearings without questioning them because there's no choice. And there is a mindset prevalent in the field now, both in arbitration and before many national courts, that we must just get on with it, that we can't just stop everything. And to get on with it means now virtual hearings. It's because as I say, there's no alternative. So I think when all this stops, we will have got so used to it. I think it will change the way that we practice, both in court and in arbitration. The difficulty in court is the need for public hearings, which is a complication. But in many arbitrations where there's no need for publicity, it's difficult to justify not doing this. It's environmentally sustainable. The way that we practiced previously was not. Very often there was needless travel for even short procedural hearings, which upset a lot of us actually. But there was an expectation that you would get on a plane and fly even if there was just a 2-hour hearing somewhere. And I think people are finding that the technology is really excellent and it will get better. You can have these hearings perfectly well, and they're happening all the time. But it has an impact on advocacy for sure. It's a different feel as an advocate. You don't have the same sort of tactile nature. The process is not as tactile in that sense. I mean, you can't connect with your tribunal in the same way. And you have to learn a different way of speaking, a different way of presenting, excuse me, to try and recreate that. There is something almost alchemical when you are standing or sitting in a room together with somebody you're trying to persuade, and you're fixing them with your eyesight, with your stare, excuse me, and you're actually persuading them. You're actually connecting with them. There's a sort of almost a tangible connection. And through a camera, remotely, that's quite difficult. And so we all have to relearn this. There are many things to learn. I mean, for example, I'm now, if I speak now, I'm looking at the camera. So that means you're probably seeing me looking at you. But my temptation is to look here, because that's where I see you. And the great temptation is to look here, because that's where I see some other participants. And I'm avoiding looking there, because that's where I see me, which is very disturbing. So that's a whole exercise you have to learn. Now, positioning of the camera. This is a whole thing we don't learn normally in advocacy. You've got to position your camera correctly. Now, my camera is pretty much at my eye level. You'd be surprised the number of hearings I have already done where people look down at their laptops where the camera is embedded. And you get this new phenomena of the up nostril effect, which is deeply disturbing for anybody watching. So these are, again, top tips that we will all learn, but we will have to, because the situation has changed. And these are things which we can overcome. It's perfectly possible to do that. They're new tools of the trade. I think also for arbitrators, sitting as an arbitrator, having a witness on a screen is not the same as having them in person, but I actually believe it's almost as good. Actually. And in the end, if anything, you get a close-up of the face that you don't get when you see them in person, which can actually be quite interesting for a decision maker.
Now, we've actually got quite a few questions that have come through. So if it's okay, I might just ask one of these questions that have been posed by our audience. So this question's from Davison Kanga. With virtual hearings, what do you do with a witness who pretends that they can't hear the question when in reality they want to avoid answering the question?
Yeah, that's a very, very good question. Now, you get that with witnesses in person also. Witnesses frequently will pretend not to understand if they don't want to answer a question. That can be witnesses who are old and they play on their age. It can be witnesses who are speaking through a translator or who are not speaking in their mother tongue. The answer is, again, once you look at the situation from the perspective of the arbitrator or the judge, this is very obvious when it happens. So as counsel, it's not something that you need to be overly concerned by. If you're putting the question in a way that's readily understandable, and the witness is pretending not to understand, that will damage their credibility. And often you don't need to do very much. You will put your question a number of times. You make sure that the question is as simple as possible. All the more so if you're remote, all the more so if it's through a translator. And if the witness is still unwilling to understand it, then you leave it hanging there and you move on. But of course, you've got to be confident that you have got to that stage where you really can't simplify anymore. I can give you one little example of where, from memory, where one witness has tried to do this, has tried to not answer on the basis of infirmity. I was sitting with an arbitrator and watching a cross-examination, and counsel put a question a number of times, and the witness did not want to answer it, was being very evasive. And then the exchange got a little bit heated, and the witness then said, unwisely, he said that he resented being have these questions posed. He was being put under unfair pressure because what counsel didn't understand is he's an old man. And then he said that he was 84 years old, not knowing that the arbitrator that I was sitting with was 85. So this is where it can backfire. There was a shifting in his seat of the arbitrator next to me, thinking that he'd just been called a very old man. But it was all obvious what was happening. So the answer to the question is, don't be overly concerned. Test it by reference to how it will appear to the tribunal.
Thank you. We've got another question here from Naomi Masumi. Should tribunals consciously avoid placing weight on the demeanor of witnesses given the complexities posed by virtual hearings?
That is another excellent question. And I'm sorry to report to everyone, it's a kind of pet topic of mine. So I'm going to try and not to speak for as long as I've been speaking before. It's interesting. Tribunals are put in, and judges are put in a position of testing credibility when they hear testimony. That's part of their exercise. They need to know whether the testimony that they're hearing is right, whether it's truthful. That involves reading people. Now, reading somebody is difficult remotely, very difficult, because of the lack of access to body language, because of the artificiality of the screen that's interposed in between. So a quick answer is to say it can be harder to judge credibility when you are not seeing somebody in person. But actually there's much more to be said, because I actually think that even when tribunals hear people in person, they are very unqualified. Generally, they're totally unqualified to actually test credibility. There's no training in it. People assume that arbitrators can read people. They can read body language, but how can they read it? How good are they actually in knowing whether somebody is telling the truth? Some tribunals have very simple, simplistic assumptions, which is that hesitation might mean a lack of candor, or speaking quickly, or speaking too much. But why does that mean lack of honesty? It is again a cultural issue. It's a personal issue. Some people like me sometimes speak too much. Doesn't necessarily reflect honesty. Some people hesitate. Some people hesitate and they stammer, not because they're trying to avoid the truth, because they're nervous and they've not been relaxed beforehand. Actually, what you need are psychologists to sit with the arbitrators to really determine credibility. So this is an area that goes beyond COVID-19. It's actually a very, very important area for arbitration generally. There is a book by Malcolm Gladwell, which has just came out recently, actually last year, called Talking to Strangers. I recommend that to people. Very, very interesting about misconceptions that anybody can actually can suffer from about other people, about who they are and what they're about and what their makeup is. So we have that difficulty anyway. That's for another webinar, but it is compounded for sure. The one thing I would just add though is I wouldn't say that it means that the process is not worthwhile. I think there's a lot one can tell still from somebody on a screen, and you can test that yourself when you listen to politicians being interviewed on television. When a politician is evading a question or being arrogant or shifty, you can often tell, even though you're not in the room. So there is a certain amount of information which you will always get anyway, even on a screen.
Okay, thank you very much for that. I've got another question here from the audience. So this is from Han Lee. What are the techniques that you find very often useful when you prepare and coach your witness from a counsel's perspective?
All right, this is a trick question. It's a trick question because in some systems, including my own, that is in the English system and the Singapore system, you're not allowed to coach your witness. So I just want to make sure I've made that point for the record. But what you mean is to prepare the witness, that is to make sure that the witness is ready to be cross-examined. Coaching would mean actually putting them through a dress rehearsal and giving them the answers, which by the way is done in many systems and is often counterproductive because it's also pretty obvious to the tribunal when it's happened. It's a very, very important process to get your witness ready to be cross-examined. It is negligent, it's irresponsible if you would just let your witness go into a witness box without the preparation. And the reason for that is that cross-examination is an entirely artificial exercise. It's not an exercise that most people would ever have been through before. And so it's only fair to them that they are made ready for it, to know what to expect. And by that I mean, regardless of the substance of the testimony, to be ready on a personal level, to know what it's going to be like. So I would always, with witnesses who I'm calling, I would go through a process beforehand of just describing what it's going to be like. I don't like myself, I'm not in favor at all of dress rehearsals, which I think actually changes the nature of testimony and makes the whole system something very different. But without doing that, you can explain to a witness what will happen. You'll go into the box, you'll sit down, it'll look like this, the room will look like this. The tables will be arranged in this way. People will behave in this way. You can ask to take your jacket off. You address the tribunal in this way. There'll be water. You can ask for anything you want. You can ask for a break. You can say, I don't understand the question. So there's a whole process that's terribly important, including making sure what the witness is going to be wearing. You'd be surprised. Witnesses often, some witnesses may not have a suit, may never have worn a suit before. They may not want to wear a suit. And if they wear a suit, they may feel very uncomfortable and thereby not be a good witness. Equally, they may feel terrible if they come underdressed without wearing a suit. And if you want to help them with that, that's all part of just the personal preparation. So that's all on the personal front. Then there is an exercise in actually getting the witness ready to have the testimony to provide. And that means making sure that the witness is up to speed, has remembered, is recalling whatever the witness has previously testified. And in our system, witness statements may have been provided by the witness maybe a long time ago. So they've got to have that ready in their minds because they'll be asked questions about that. It's that kind of preparation. Where the line is drawn, of course, is very important. What you're not supposed to do in many systems is to say, and if you get this question, the answer is this. Remember, what's the answer? It's this. There are 3 reasons. Do you remember? 3 reasons why you did it. Now repeat them to me. That's coaching. So it's a very important exercise, but I'm going to take too long if I spend more time on it. But it's an important role for counsel.
Now we are a bit past the hour. So did you want to stay on just to take a couple more questions from the audience?
I'm happy to. Can I just say, I just noticed one question that's popped up on my list, which says, what is the book that I mentioned?
Yeah.
And the book is called Talking, I've got it here. It's Malcolm Gladwell, Talking to Strangers. It's nothing to do with law, but you read that and you will reassess the way that we deal with witnesses.
Thank you for that, Toby. So I've got a question here from David Angway N. From your experience as leading counsel, what are the best ways for solicitors and/or junior counsel to help leading counsel, or to add value to the presentation of the case at various stages of the proceedings?
It's a great question. I have this experience, which is quite frequent. I have this, and again, I'm going to say this without naming names until the day after I retire, when it'll all be published. I have this experience of arriving at a hearing, at arbitration hearings, frequently, and I sit in the first chair for counsel on my side. So I'm sitting there, and let's say to my left, I've got the 3 arbitrators. Opposite, I've got opposing counsel. When I turn to my right, I've got a long line of people on my side. The person directly next to me will be my junior. The person next to him or her may be another junior. And then there'll be solicitor, the partner or senior associate, and then the team that I know. And then when I look further down, there'll be a long line of people that I have never seen before. And they all apparently are lawyers on my team. And they, when one gets to assess costs at the end of the day, have apparently spent a lot of time writing memos and researching points. And none of that has made its way into my notes. It's only what is in my notes that will get communicated to the tribunal. So in most cases, there is a lot of work that's done by junior counsel or solicitors and lawyers in the team that is not part of the overall, not part of the essential submission. It's work which costs money, it costs the client, and it never really contributes. So the way around this is to make sure that the entire team is fully joined up from the start. And that means connecting with your senior counsel from the start to make sure that the senior counsel rolls up his or her sleeves to actually get into the case early and to delegate tasks and to know who is doing what, when, to avoid duplication. And also it means that senior counsel knows who is doing what and then can work directly with that person. And often that means actually separating out issues. So you'd say in a big case, right, this part of, let's say, quantum, I want so-and-so to deal with, and that's the person that I will liaise with. And then having that frequent contact with counsel, not just a few weeks before the hearing, way before that, to actually work up issues. Teams tend to be overly big, with a lot of redundancy, actually, I think, in terms of the work that's done. And so I think it's something which needs to be focused on early. It's obviously in the client's interests, and it's in senior counsel's interests to have a team that's really tight and works closely together.
And when we were preparing for this interview, Sonal actually mentioned that you have a couple of interesting stories. So Sonal, do you want to put your question to Toby?
Yes, Solano, I mean, we have all have our share of funny and embarrassing stories during our practice and our advocacy and our hearings. Is there something which you would like to share with us, such kind of a story and how you navigated your way out of that situation?
That's a really difficult, it's a really difficult question. And now, do you have something in mind that I've mentioned before? It sounded like the introduction to that sounded like.
Yes,
right. Then you can answer for me. That's even better.
I think I remember you mentioning about a hearing where you were with Martin Hunter. I think on the tribunal, if my memories helps me well, it was Alan Redford or Johnny Weeder.
All right. So now, then I will definitely tell you the story, but I have to apologize first of all, because there may be some people who are listening to this who will have just heard the same story. Because I did an interview, I think about a week ago or thereabouts, and I was asked the question, and I mentioned this case. But because you've now asked me about it, I'll repeat it. And anybody who watched that previous webinar can see whether the story is now different or not. This was my first arbitration, my first ever big international arbitration, and it was a hearing that took place in Washington, DC. I was a very junior lawyer. And it was a case where I was instructed alongside Professor Martin Hunter and Lucy Reed, very senior practitioners. And on the tribunal, the chair of the tribunal was Johnny Weeder QC, sitting with the ex-general counsel of the World Bank and the Attorney General from Trinidad. And it was a curious case because our instructions were to lose the case. They're not instructions you would get frequently. but we were asked to lose the case, but on jurisdiction, not merits, because there was an interest in exhausting remedies in order to proceed under a political risk insurance policy, which had a different arbitration system. And the precondition of that was this ICC arbitration had to have failed, first of all, or ended. So we argued a case, and we argued a case which wasn't the strongest case, and we lost, which meant we won. But in the course of that, Martin Hunter had to argue a particular point of jurisdiction. It was the ICC doctrine of groups of companies. It's an idea that there is a principle within ICC arbitration which allows you to pierce the corporate veil. Martin Hunter argued this point, and it sounded awful, because it was awful. And so we all looked away and hoped that he would just move on quickly. And he tried to move on quickly to the next point. Johnny Vida, who is a purist, was a purist, and knew all these points of law backwards, stopped Martin Hunter and said, Professor Hunter, I'm sorry, but the tribunal has not understood this point. Could you please repeat it? So poor Professor Hunter had to argue this terrible point again. And the second time it sounded even worse. So he then tried to move on, and he was stopped again. Johnny Vida said, Professor Hunter, I apologize, but I'm afraid the tribunal is still struggling to understand how this point works. Can you please repeat it? So Professor Hunter repeated it again, and this exchange went on and on. Johnny Vida would not let go. And every time Martin Hunter tried to reframe the answer differently, it got even worse. Until finally, Johnny Vida gave him one last chance and said, Professor Hunter, I'm sorry, but the tribunal is going to give you one last chance to argue this point. At which point, Martin Hunter had his moment of inspiration. And that's when he said to the tribunal, oh, you mean that point? No, that point will be argued by Mr. Landau. And that was my entry into international arbitration, at which point apparently all blood drained from my face. Johnny Vida saw exactly what was happening. Johnny Vida started to giggle, and then that giggle matured into something which was uncontrollable, as giggles sometimes do. He could not stop laughing. In fact, he couldn't breathe, I think. He went bright red, and he started to make these odd imploding noises. So he looked down and he was shaking. He was a very large man. He was shaking. He just couldn't stop, until finally he had no choice in the middle of the hearing but to stand up and run out of the room, which he did. So he ran out of the room, and then there were these odd noises outside as he was trying to breathe and regain his composure. And then he came back into the room, and for the rest of the day, we avoided all eye contact. And we moved on to the next point. And I'm afraid it's a story which I do repeat, and everybody's probably heard it before because it was formative.
Thank you so much. Thank you, Mr. Landau, for repeating that for us.
And look, we're now about 15 minutes over time, so this will be the last question for the afternoon. And this does tie into one of the questions that our audience has also posed. So what advice do you have for students or young practitioners on how one may go about forging a career in international arbitration? And one thing that I've actually noticed over time is that there is a push for people to go on to higher education, to either the United States or to the UK, to further their knowledge and expertise in international arbitration. So is this something that you'd recommend?
It is a highly competitive field. It is a very popular field. That is a result of what's happened over the years, a big change that I've seen since I've been practicing in the field. When I started, it was a smaller field with fewer opportunities. Very, very difficult for people who are young to break into it. Dominated by older people, dominated by white males, European and American actually, essentially at the time. So now we have moved on greatly from there. There's an awful long way to go, but it means that the field is much bigger now. There are many more opportunities. It's not so dominated by this small group. And so I think also there are more opportunities for younger people to move into the field. But because many people want to do that, it is competitive. And that means that you need to differentiate yourself from other people. That's the truth. And it's a harsh truth, because there are people who are very, very skilled and talented, but they have to somehow, they've got to compete, and they've got to be noticed. And there are different ways of being noticed, different ways of differentiating yourself. One way of differentiating yourself is higher education, but that's not available to everybody. If you have it available, if you have the possibility of studying more, I would highly recommend it. I studied for as long as I could. I did many courses, a number of degrees, until I was at risk of losing credibility and had to get a job. But I think I've never looked back. There's no rush to start. It's not a question of starting young. There's no disadvantage if you come to the field later and if you've studied more. And studying more will open your mind to more possibilities, and thereby be a better practitioner. So if you have the opportunity, scholarships or any other funding, and you can do it, then I recommend it. And then you can differentiate yourself. When people look at CVs, they will look at master's degrees, they'll look at extra courses. And nowadays, unlike the older days, there are so many courses available in international dispute resolution. Courses of all shapes and sizes around the world, many different durations, some a month, some a year, some 2 years. People do doctorates. There's a whole range. So I think you should do that. Now, what about if you can't do that? If you haven't got the ability, you haven't got the funding, you haven't got the opportunity, that doesn't mean you don't differentiate yourself otherwise. You can differentiate yourself simply by knowing everything you can about your own area, your own country, and its arbitration law. Teaching yourself through the amazing amount of resources that are available on the internet. Even more so in these viral days, because now you can join webinars, you can join conferences in a way that was never possible before. You can attend conferences without traveling. And that's a major change. And so you can teach yourself. And maybe you can teach yourself enough to start writing an article, start getting your name known a little bit, so that you can differentiate yourself that way. You put yourself forward by saying, look, I've done this. I know everything about Indian arbitration. I know everything about this area. I can help you on this. I've got value I can add. And there is no excuse. Anybody sitting at home now can educate themselves because there's so much freely available. Other tips are to find people to guide you. I'm totally dependent upon, I have everything to give credit for to mentors, to find somebody who can be a mentor. And I had particular mentors who guided me along the way. And that is something which you should look for. And there are mentors available. You can write to people. You can offer yourself. People do that the whole time, just cold calling. ICA, the International Council for Commercial Arbitration, has a system now. Young ICA has a system of a mentor program, which you can sign up to. And that means that they will allocate you a mentor. So I think all those, it's really a question now for young people entering the field to maximize what is available to them anyway, to build up their own expertise as much as possible and become attractive to employers, and then persevere by actually writing letters and going for all possible internships and at institutions and at firms, and that's the way to go.
Thank you very much, Toby. And that brings us to the end of today's webinar. Toby, once again, thank you very kindly for making the time to participate in this webinar. Like Sonal said, we really don't know if we would have been able to bring you on board if it wasn't for the COVID-19 pandemic. So thank you so much for giving up your time this afternoon. I'm sure I definitely learnt a lot this afternoon. I'm sure Sonal and our audience also did. So thank you so much for spreading the knowledge on international arbitration. Just before we go, I just wanted to thank our organizers, Young Arbitration Practitioners Group India and the Indian International and Domestic Arbitration Center, our hosts for the evening, AIAC and the AIAC YPG, our supporting firm, AKS Partners, and the academic partner, Galgotius University. So thank you once again. For those of you who tuning into the AIAC webinar series, which is separate from this, please keep an eye out on social media platforms for our upcoming webinars next week. So that's all from me. Thank you, Sonal, for being such an amazing co-examiner this afternoon. And thank you for the opportunity to have AIAC be part of this series.
Thank you. Thank you, Mr. Landau, and thank you, Nivvy, for making this
Thank you very
possible.
much. Thank you all. Thank you very much.
Thank you.